For admission, item number 1.
Yes.
May I please, Your Lordship? My Lord, in this contempt petition, my Lord, the matter pertains to acquisition of land. And as per the order of the learned single judge, my Lord, direction was made to make reassessment of the interest payable to the petitioners. There are 3 directions given by this Honorable Court. Firstly, for reassessment of interest payable to the petitioners in terms of Section 8P of the Act of 2013. And so far as the other 2 directions were concerned, that can be
Respondents are all represented.
not yet, my Lord. But in terms of the last court's order, my Lord, the DC Siha district had filed an affidavit this morning. I've been served the advance copy.
Okay.
Let that be on record.
Appearance has been entered for respondent number 4. What is
Your Lordship, I'm representing the respondent number 3, Cemetery Land Revenue. However, Your Lordship, the cemetery is on leave. So
Till May.
Till May, yes, Your Lordship. So we cannot file our affidavit.
For the 2
till
weeks
now.
time to fill the power and response. But will the deputy commissioner's affidavit suffice? I mean,
Subject to the statement given by the Deputy Commissioner, my Lord, the next step will be on the central government.
okay.
Now they have stated that they have made the reassessment and they have forwarded to the central government, which will be awaiting for the sanction from the appropriate.
So on the last occasion, I think Learned CGC made a prayer to that she would like to file power and affidavit in respect of R2. Yes. Okay.
In the meantime,
New
my Lord,
incumbent.
we will do the needful to impede the
Yes,
present
because that
incumbent.
will be necessary.
Yes, my
If they are now putting the blame on R2, then R2 also has to be okay.
And in respect of respondent number 1, 5, and 6, as per the last court's order, my Lord, I have taken steps upon them on 7th
on
April.
7th of
However,
April.
service reports are still awaited. We may wait for service report in respect
Okay.
of 1, 5, and 6.
Last order is 2-4,
Yes, my Lord.
2426.
Yes, my Lord.
Heard Mr. Victor L. Ralte, Learned Counsel, appearing for the petitioners. So, Learned Counsel, Ms. Vani Siami is present for respondent number 3. However, it is stated that the respondent number 3 is on leave. Till May means whole month of May.
I have to inquire. Your Lordship.
That the respondent 3 is on leave till May. Stop. And therefore she prays for some time to file the affidavit on behalf of respondent number 3. Stop. Ms. M.S. Zairam Sangpui, Learned Counsel, Learned CGC, appearing for the respondent number 2, has also submitted that the respondent number 2 has been transferred out and a new incumbent has been transferred in his place, and therefore the petitioner needs to implead the new incumbent. Stop. Learned Counsel, Mr. Such and Such.
Daniel Shasel on behalf of Ms. Mariel Kiangte for respondent number 4.
For respondent
DC.
number 4, okay. Stop. It is stated that the respondent number 4 had been directed to file affidavit.
Yes, Your
Had
Lordship,
been
we have filed.
directed. Okay. Had been directed to file an affidavit by this court's order dated 2/4/2026. Stop. It is submitted that the affidavit has been filed this morning, and a copy of the same has been served on the Learned Counsel for the petitioner. Stop. However, the affidavit has not come on record. Stop. Accordingly, list the matter. Wait. The petitioner has also taken fresh steps for service of notice upon respondents 1, 5, and 6 on 7/4/26, and the service reports have not returned till date. So, according to list the matter, after 3 weeks will do. After 3 weeks, to enable the respondents 2 and 3 to file their affidavits, and the registry is also directed to place on record the affidavit filed by the respondent number 4 today. It was filed today.
Yes, this
This
morning.
morning, and filed this morning. So, list after 3 weeks.
Date may be given, my Lord, 2nd of June. That will be after 3 weeks.
Okay, okay, 2nd June.
Please be obliged.
Item number 2.
Yes, may it please your lordship. I'm here for the petitioner, my lord.
Yes.
And in this case, the respondent number 3, 4, and 5 have filed their affidavit in opposition.
3, 4, and 5.
Yes, and
Yes.
1, 2, 6, and 7 have not filed, my lord.
Okay, yes.
I'm for respondent number 1 and 2. I will not be filing my affidavit.
You will not be filing.
Yes, Your Lordship, I'm representing the state respondent number 6 and 7.
6 and
Your
7.
Lordship, I'm seeking 2 weeks' time to file my affidavit.
Okay, okay. And who's 3, 4, 5? NHIDCL? Okay, you have already filed, no? Okay, learned counsel for the petitioner, Ms. Such and Such is present. Stop. Learned counsel, Ms. Such and Such, learned CGC, appearing for respondent number 1 and 2, submits that she will not be filing the affidavit. Stop. Learned counsel, Ms. Vani Siami, appearing for respondent 6 and 7, please for 2 weeks.
Yes,
2
Your
weeks' time to file the affidavit on behalf of respondent 6 and 7. Learned counsel, Mr. Samuel Such and Such, appearing for respondent 3, 4, and 5, has submitted that the affidavit has already been filed. So accordingly, list the matter after 2 weeks in order to enable the respondent 6 and 7 to file their reply affidavits. Okay, list after 2 weeks.
Oblige.
For orders, item number 3.
Please, Your Lordship.
Yes.
My Lord, in this instant bail application, TCR has been received. And my Lord, there's
Yes, yes. The court had asked for the order sheets,
yes, my Lord.
scanned
the order
copies of
sheets.
the order sheets. Has it come?
My Lord, before we move further to this case, my Lord, I am here to seek the withdrawal of the present bail application, my Lord.
Withdrawal?
Yes, my Lord.
Oh, okay. With liberty or?
Liberty to file afresh, my Lord. Since there is a discrepancies between the my client's instructions and the trial court's communication, my Lord.
Achha. In any case, the court orders also, order sheets is also not here.
Yes, madam.
Learned counsel, Mr. You are Ricky, na?
Yes, my Lord.
Ricky Lalrot Fella, learned counsel for the petitioner, prays that they may be allowed to withdraw the instant petition with liberty to file afresh. So, prayer is allowed. The petition is disposed of on withdrawal with liberty to file afresh.
Obliged, my Lord.
Item number 4.
None appears for the appellant when the matter is called list after 2 weeks.
Item number 5 and 6.
My Lord, here there is a delay of 107 days in filing the connected appeal. This is the first time, my Lord.
Will condone. The instant application under Section 5 of the Limitation Act has been preferred, praying for condonation of delay of 107 days in filing the connected appeal against the impugned judgment and order dated 18/11/2025, passed by the special judge. Is it special judge or?
It's a Judge
By
Fast
the
Track
Judge
Court.
Fast Track Court, Kolasib, in SCK, K in brackets, number 32/2022, arising out of, in connection with criminal trial number 164/2022, by which the appellant/applicant was convicted under Section 4 of the POCSO Act and sentenced to undergo arrai for a period of 10 years and to pay a fine of Rs 5,000, comma, in default to undergo array for another 1 month. Stop. Para. Heard learned counsel for the applicant, Sri such and such. Stop. The grounds taken, the reasons given by the applicant regarding the delay has been set out at paragraphs 2 of the application. So the court has gone through the same and is satisfied that sufficient reasons have been shown by the applicant with regard to the delay, and accordingly the delay of 107 days is condoned. The learned PP, Ms. Venisiami, also has no objections regarding the condonation application. So accordingly the matter is, IA is disposed of, allowed and disposed of. Then the main criminal appeal. Okay. Your grounds page.
My grounds is from page 4, my lord.
Page 4.
After the impugned judgment and order.
Oh, yes. The present appeal under section 415 clause 2 BNSS has been preferred against the impugned judgment and order dated 18/11/25. Same, okay, like in the IA. Such and such, convicting the such and such. Then stop. Heard learned counsel for the appellant, Mr. Such and such. Stop. The main grounds taken by the appellant herein is that the learned trial court had wrongly come to a conclusion that the incident of sexual assault narrated by the prosecutrix to her mother, comma, her statements before the magistrate under section 164 CRPC, comma, her deposition in the trial court, comma, are the grounds on which are the evidence which has proved the case fully. Stop. However, it is submitted by the learned counsel for the appellant that the evidence shows that the offense came to light only when the prosecutrix, out of the blue, told the informant that she had been sexually assaulted. Stop. You're talking about contradictory statements.
Yes, the evidence of the
Therefore, it is stated by the learned counsel for the appellant that the learned trial court has not taken into consideration that the evidence is contradictory and concocted, and the evidence of the prosecutrix is also not of sterling quality. Stop. Para. Admit the appeal, call for the records. Stop. Learned PP, Ms. Venisiami has accepted notice on behalf of the state respondents, hence no formal notice is called for. Stop. However, since this is a POCSO matter, the appellant shall also take steps for service on the respondent number 2/applicant through the registry of this court. Through the PP,
yes,
through the
lord.
office of the PP, and the learned PP shall thereafter apprise the court regarding the service of notice.
Your Lordship,
Yes.
in this regard, because this is not a jail appeal, and the service cannot go through the PP, they themselves has to serve. If it is a jail appeal, the PP will do the needful things. But now this is a
No. I think in POCSO, in all the appeals, it is done through the PP. At least in principle, seat also and Kohima bench also we do
understand
that.
But in some cases, they themselves send through the IO, not through the PP.
No, but there is a standing notification of the Guwahati High Court, which says that it has to be. And then that notification is also there. There is a standing notification. Okay, so shall take steps through the office of the PP, and thereafter the learned PP shall apprise the court regarding the service of notice on the respondent number 2. Okay. You serve the copies on the PP,
Yes,
and then through the jurisdictional
Police
OC it will be
station,
done. Yes. At least after 4 weeks.
I'm obliged.
Part 2 hearing, item number 8.
None appears for the appellant when the matter is called. List after 2 weeks. Okay. Item 8 hearing. That's all.